Kidnapping charges in Cherokee County are serious criminal accusations that can carry severe punishment and long-term consequences. A kidnapping allegation may arise from a violent event, domestic dispute, custody conflict, relationship breakdown, intoxicated argument, misunderstanding, or situation where one person claims they were restrained, confined, or moved against their will. Because kidnapping sounds extreme, people often assume the charge only applies to ransom demands or stranger abductions. In reality, Oklahoma kidnapping charges can arise from a wider range of alleged conduct. Understanding kidnapping under Oklahoma law. In Oklahoma law, kidnapping generally involves taking, detaining, confining, or carrying away another person without lawful authority and against that person's will. The exact charge and punishment depend on the facts, the alleged purpose, the age of the alleged victim, whether force or threats were used, whether another crime was involved, and whether the alleged victim suffered injury. The state must prove every required element beyond a reasonable doubt. A person should not be convicted of kidnapping simply because an argument occurred, someone felt pressured, or the facts are emotionally charged. The law requires proof that the accused engaged in conduct that meets the legal definition of the charged offense. Common situations that lead to kidnapping charges. Kidnapping allegations may arise in several different ways. Some cases involve accusations that a person forced someone into a vehicle, kept someone from leaving a room or house, moved a person during an assault, held someone during a robbery, or restrained someone during a domestic dispute. Other cases involve family or custody-related conflicts. A parent, relative, or partner may be accused of taking or keeping a child in violation of a court order. These cases can be complicated because criminal law, custody orders, parental rights, and the specific facts all matter. Kidnapping and domestic disputes. Many kidnapping charges begin as domestic-related allegations. During a heated argument, one person may claim the other blocked a doorway, took car keys, grabbed them, forced them into a vehicle, refused to let them leave, or moved them from one location to another. These facts may support a serious charge if proven. However, domestic cases can also involve exaggeration, conflicting stories, alcohol or drug use, emotional statements, and incomplete evidence. The defense must carefully examine witness statements, 911 calls, body camera footage, photographs, medical records, text messages, and the timeline of events. Kidnapping and child custody issues. Kidnapping allegations involving children require special attention. A parent may believe they had authority to take or keep a child, while the other parent or the state may claim a court order was violated. The defense may depend on the custody order, visitation schedule, emergency circumstances, prior agreements, communications between the parents, and whether the accused had lawful authority at the time. A custody disagreement does not automatically equal kidnapping. However, violating a custody order or hiding a child from the other parent can create serious legal problems. Anyone facing this type of allegation should speak with an attorney immediately. Possible punishment for kidnapping. Kidnapping can carry significant punishment in Oklahoma. The exact sentencing range depends on the specific charge and facts. Aggravating facts, such as injury, threats, weapons, sexual assault, robbery, domestic violence, child victims, or prior convictions, can increase the seriousness of the case. A kidnapping conviction can also create consequences beyond prison or probation. It can affect employment, housing, firearm rights, custody rights, reputation, and future criminal history. In some cases, kidnapping may also be charged alongside assault, domestic abuse, robbery, burglary, child endangerment, protective order violations, or other crimes. Consent as a defense. Consent can be an important defense in some kidnapping cases. If the alleged victim voluntarily went with the accused, agreed to remain in a location, or was free to leave, the state may have difficulty proving kidnapping. Consent defenses are fact-specific. The defense may focus on text messages, video, witness observations, prior relationship history, travel plans, phone records, and whether the alleged victim's conduct was consistent with someone being held against their will. Lack of force, threat, or restraint. A kidnapping charge may fail if the state cannot prove unlawful restraint, confinement, seizure, or movement. Not every argument, uncomfortable conversation, or heated encounter amounts to kidnapping. The defense may argue that the alleged victim was not restrained, was not moved against their will, had access to exits, had a phone, could leave, or did leave freely. The facts must be reviewed carefully because the legal issue is not merely whether someone felt upset or pressured, but whether the elements of kidnapping can be proven. Lawful authority may be a defense in certain cases. A parent with legal custody, a person acting under a court order, law enforcement, or someone acting in an emergency may have a lawful basis to move or control another person under limited circumstances. This defense depends heavily on the facts and documents. Custody orders, guardianship papers, emergency circumstances, law enforcement instructions, and written agreements may all matter. Mistaken identity or false allegations. Kidnapping cases may involve mistaken identity or false allegations. A witness may misidentify the accused, misunderstand what happened, or exaggerate due to anger, fear, custody conflicts, relationship problems, or pressure from others. The defense may challenge inconsistencies in statements, the lack of physical evidence, gaps in video footage, discrepancies in phone location data, witness credibility, and changes in the accusation over time. Insufficient evidence. The prosecution must prove the case beyond a reasonable doubt. If the evidence is weak, inconsistent, unsupported, or missing key elements, the defense may argue that the state has not met its burden. Evidence in kidnapping cases may include witness statements, 911 recordings, medical records, photographs, surveillance footage, body camera video, cell phone records, GPS data, social media messages, and physical evidence. A careful defense review may reveal that the evidence does not support the charge as filed. Constitutional defenses. Kidnapping cases may also involve constitutional issues. The defense may challenge an unlawful stop, illegal arrest, improper interrogation, involuntary confession, illegal search, or violation of the accused person's right to counsel. If evidence was obtained unlawfully, the defense may ask the court to suppress it. Suppressing key evidence can change the direction of the case. In some cases, it may weaken the prosecution's ability to proceed. Lesser charges and negotiations. Sometimes the facts do not support kidnapping but may support a lesser offense. Depending on the case, the defense may argue that the evidence, if anything, supports assault and battery, domestic abuse, interference with custody, protective order violation, or another lesser charge rather than kidnapping. Charge reduction can make a major difference in sentencing exposure, plea negotiations, and long-term consequences. This is why the defense should not accept the prosecution's label without reviewing the facts and law. Early legal representation can help preserve evidence, protect constitutional rights, review witness statements, examine court orders, and challenge weak or exaggerated allegations.